Hi, my name is Christina Fisher. I'm an Assistant District Attorney at the Jefferson Parish District Attorney's Office, and today I'm going to be talking about some new legislation that our office helped push through in the interest of helping crime victims, and that is Act 246, and it goes into effect on August 1st of this year. That law deals specifically with protective orders, and so when we refer to protective orders, there's a lot of different ways that you can get them under the law. One of them is when it's attached to a part of a criminal case, and that's what our office is concerned with. So we help push this legislation through to help crime victims have that added layer of safety when it comes to the issuance of restraining orders. When I refer to restraining orders as a criminal case, there's even a couple of different ways that that can be attached to a case. One is as part of an open criminal case, and we refer to those as bail restrictions. So as soon as the defendant is arrested, our office and the judges are immediately able to issue that layer of protection for the victim in either as part of a special hearing or right away in the jail, issuing, along with the defendant's bond, which is a promise to return back to court, along with that, issuing a restraining order. So the defendant not only has to pay that bond or have someone pay that bond, but on top of that, the defendant is personally served and has to sign a restraining order requiring that if he's going to be out of jail, there is no contact with the victim. So that defendant has that added requirement as upon leaving the jail to not contact the victim. One thing that Act 246 does, in addition to that, even if the defendant is still in jail and has not yet posted the monetary bond, the defendant still cannot have contact with the victim when a restraining order has been issued. Previously, there was a bit of murky water in terms of when the defendant had not yet been released from jail, if that order applied. Now this law clarifies that if the judge issues a restraining order as part of a case, even if the defendant is still in jail, the defendant can't be contacting the victim from jail, whether through third party or directly. That is officially now a violation of a restraining order. Another really important thing that Act 246 accomplished is something that especially came to light during the coronavirus shutdown, and that was the fact that these restraining orders that were part of a criminal case had expiration dates previously. That is no longer. Now, if a judge issues a restraining order as part of an open criminal case, that order is effective through the duration of the case. So if the case is open, that victim is protected by that restraining order. So it fixes the problem where you're having an open case, having a restraining order that was previously up to the judge's discretion, maybe 3 months, maybe a year, maybe 2 years. You could have that order expire while the case is still going, and then you're having victims that are frantic because they know that the order is expiring and they're afraid that the defendant knows that as well. So now that's not going to happen, and defendants know that as long as the case is open, as long as the case is ongoing, they are not to have any kind of contact with the victim. And so while I'm on that topic, when these orders are issued, there is what's called a Louisiana Uniform Abuse Prevention Order. And so there's all different kinds of restraining orders, civil, criminal, different types of orders, but each time an order is issued, the judge must fill out this uniform order. That's the same one that the defendant is personally served with and signs, and that order goes into a statewide registry. Any law enforcement officer can access that registry, so victims sometimes wonder, do I have to keep the order with me at all times? And the answer is no. If the defendant is violating a restraining order, the victim all the victim needs to do is contact the police and let them know there's a restraining order in effect and the defendant is contacting me or coming near me, and the police can look in that registry and see, in fact, there is a protective order and see the effective dates and verify that. So that's an important thing to know about protective orders as well. If the case is closed, so when I say closed, that means either the defendant has pled guilty or is found guilty, or I'm going to talk about a third option in a minute, but once the case is closed, as a part of the sentence, a judge can issue a restraining order as well, and so that's what we call a sentencing order. The same Uniform Abuse Prevention Order is issued, but Act 246 extends the court's ability to do that as a sentencing order in more types of cases, so giving victims an added layer of protection in different types of cases where the case is over but the victim wants to make sure that they're still protected. Act 246 extends that. As well, Act 246 extends the court's ability to also issue GPS monitoring. and that's as a condition of bail. So the case is open, victim has concerns, there's maybe a restraining order already in effect. The judge can add that protection of having a GPS monitoring so they really know where the defendant is and making sure they're not a danger to the victim. Additionally, this Act 246 requires in certain violent offenses that judges issue restraining orders as a condition of parole. So if a defendant is going to be given parole, let out of jail on specific terms, one of those terms has to be that there's a restraining order. So it takes the ability to issue a restraining order, that decision-making process, away from the judge, and just simply says that they must issue a restraining order in these types of cases. So going back a little bit to what I was saying about when a case is closed. So a defendant can be found or plead guilty, and now under Act 246, if a defendant is found not guilty by reason of insanity, even though that's not guilty and the case is closed, a judge now can issue a restraining order as part of that as well. So the defendant, though not guilty, a victim may have concerns about the defendant getting help. The defendant will be monitored under certain properties for the not guilty verdict, but as well, they're going to be able to have that layer of protection. The defendant would be maybe getting help, but also still staying away. So we hear that a lot where victims say, I just want him to get help, but I don't want him to bother me. And this is one way for courts to do that. We're so grateful for the relationships that we have with our legislature that allow us to advocate on behalf of victims to make sure that the law reflects what they need. And as assistant district attorneys, we're able to see what they need in a different perspective, seeing sort of as boots on the ground what happens in the courtroom and how that impacts the victims. So we're always wanting to continue to strive to help victims and see that the law reflects their interests. And specifically for this law, we have to thank Senator Gary Smith Jr. for authoring the bill, and also thanks to Representative Joe Marino for helping the bill as it passed through the House of Representatives. Thank you so much for watching all the way through to the end. Have a great day and stay safe.